Sanjay Hegde, would you want to go first on what is your opinion in the legal interpretation of what the top court said today?
No, the legal interpretation is that notwithstanding a presumption of constitutionality, the top court has found certain provisions which it prima facie says that please put them on hold till we examine the matter fully. Now, just to explain, any act made by Parliament is presumed to be constitutional. You can challenge it in a court. The court will start with the initial presumption that, look, if Parliament has done it, they will have the powers. It may not necessarily infringe on fundamental rights. So the petitioners have to make out a case for an interim order of stay. So the fact that certain provisions have been found prima facie, at least, to possibly lack competence or something of that kind, shows that the Supreme Court believes that there is material in the objections which the petitioners have raised.
Okay. Aman Sinha, would you want to weigh in on how are you going to legally interpret what the top court says? Because, there is a point that Sanjay Hegde is making that prima facie the court has found that some of the provisions are deeply problematic and those have been stayed. Once, of course, the court hears the case.
Preeti, first of all, what court has said categorically is that there was a prayer to stay the provisions of the entire statute. That prayer has been rejected, and the Supreme Court has very categorically stated that no case for blanket stay of this sort has been made out, and in fact any case for such blanket stay of the entire act has been rejected. This is the foremost point. Secondly, prima facie, as you very correctly pointed out, Preeti, this is an interim order, but even by a prima facie examination, it seems that the legislative competence of the Parliament has also been exceeded and approved by the Supreme Court. Otherwise, it could have been rejected on the first look itself. Thereafter, whatever other balancing measures that the court has adopted, it is only to they are mostly procedural rather than substantive. For instance, as you were saying that the provision of 5 years practicing Islam, that particular provision has been stayed because of paucity of exact rules which would determine when a person has adopted the religion of Islam, etc.